Mr. Crowley.
Good morning. May it please the court, counsel. My name is Steve Crowley. This is my partner, Andrew Mahoney, and we represent Roy Karon and Pedler, the plaintiff appellants in this case. As the briefs show, this is a case which focuses on the interplay and the balance between tort law, which protects societal interests of everyone, and Iowa contract law, which protects private interests and expectations made in agreements. Plaintiff appellants submit that when the two appear to conflict, as they might if one looks at the briefs in this case, societal interests should always take precedence over fraud and protect honesty in contracts, because those interests are created and are important in both tort and contract law. Contract law should never be used to perpetrate fraud with impunity and defeat societal norms and appropriate contract expectations. This case began with a simple oral contract. My client, Roy Karon, who is a businessman and an avid pilot and who uses his aircraft for business across the United States and into Canada, contacted Jim Mitchell, the vice president of Elliott Aviation, and said, I want to sell my Bravo. There's the plane that he was using at the time was called the Citation Bravo, and he wanted to buy a larger and faster airplane called a Citation 10. He called Mr. Mitchell and said, look, I don't want to recapture the depreciation on Bravo, so I'd like to do a 1031 exchange. You may have the Bravo in trade-in at whatever price we can agree on, and then I will pay you $100,000 to broker in this situation. I will go find the airplane I want, the Citation 10, because I can do that. I will negotiate a price for it, and then I will pay Elliott's $100,000 over and above the acquisition price for you to handle the transaction. Mr. Mitchell agreed, and the deal began. Within a couple of days, both men found a couple of candidates for the Citation 10 on the internet and in the same systems where...
Mr. Crowley, can I interrupt you for a second here?
Yes.
The purchase agreement, did it contain this side agreement?
I'm sorry, Your Honor.
$100,000?
It did not. It did not mention the brokerage agreement or the $100,000 compensation, but the money was paid for some...
I understand, and the purchase agreement also said this is the entire contract between the parties, didn't it?
It did.
So are we dealing with two separate contracts, one for the $100,000 and one for the purchase of the plane?
Yes, Your Honor. I think you are. And that's clear because one had to be breached before the fraud could be created. The deal was, I will give you the profit you make off the Bravo plus $100,000 to help me acquire the Citation 10 without having to recapture the depreciation.
Is that oral contract enforceable?
Yes, Your Honor.
Doesn't have a choice of law question in it, does it?
I'm sorry, Your Honor.
The oral contract didn't agree on a choice of law, did it?
No.
The oral contract didn't ask for arbitration, did it?
No.
On the oral contract, though, isn't the $100,000 worked into the pricing on the written contract? Isn't that fit into it? Isn't that where the $100,000 would come from? What the problem was that the other side, you overstated how much they actually had to pay for the airplane. Isn't that the issue?
You're correct, Mr. Justice. The acquisition, I like to use the term acquisition price because that was the key in the oral contract. You say, whatever I can negotiate for the Citation 10, I will pay you $100,000 over that price just for brokering this deal. And brokerage deals happen all the time.
And that $100,000 was worked into the written contract, correct?
Ultimately, the acquisition price is reflected in the written contract, including the $100,000 plus the $400,000.
But the problem is that they actually paid less for the airplane than they claimed. There was a fraud. Is that the issue here?
Yes, Your Honor, that's correct.
Now, these are sophisticated parties, your client and the other side, right? This is a multi-million-dollar transaction involving an aircraft.
That's right.
The written contract says any dispute arising under, out of, or related in any way to this agreement, pretty broad language, will be adjudicated solely and exclusively in the courts in Wichita. Why shouldn't we enforce that?
Because, Your Honor, the acquisition price had to be the fraud that was the acquisition price. The misrepresentation preceded Exhibit AA. It was done. It was over with. They told him we paid, well, I forgot. I would like to add this point. During the performance of the oral contract, Mr. Mitchell approached Mr. Karon and said, I would like to be your agent. I'd like to be your purchasing agent because I can deal with Cessna turbines and get you a better price. So Mr. Karon said, go ahead. And I think this is one of the keys to this case, and it demonstrates the problem we have here, which appears to be a conflict of law, which shouldn't be. Mr. Karon says, yes, go ahead, do the best you can. Mitchell then makes the first misrepresentation. They, meaning Cessna, want $6 million. Mr. Karon, trusting that Mr. Mitchell will represent him honestly and fairly in this deal, says, the most I will pay is $5.8 million for that airplane. That's it. So Mitchell now has inside information that he's supposed to use as a fiduciary for Mr. Karon. He goes to Cessna, and he cuts a better deal. He gets a deal for $5.4 million. And he tells Mr. Karon, you now have your airplane for $5.8 million. So the fraud was created in the acquisition price during the performance of the oral agreement, and then it was just plugged into the written agreement.
And that may all be true, but as I read the restatement of conflict of laws, in order to avoid one of these forum selection clauses like this, you have to show a fraud with respect to that specific clause, not merely a fraud in the transaction. And you're not arguing a fraud as to that specific clause, are you?
As to the forum selection clause?
Right. Yeah.
Yes. No, I'm not. Excuse me. Correct. I am not. I don't think that, I think it's clear. We believe that the appropriate law governs this case is in our brief, and that is you can't sever a clause out of a written agreement that was void from the beginning. I mean, and this is one of our primary arguments, this is not peripheral, this is not fraud and the inducement out on the periphery of the deal. This goes to the very heart of, what's the one from law school, I'll paint your house for $1,000, and then your house turns out to be a 50,000 square foot
I'm having
building.
a little bit of trouble reconciling kind of what you just said, which is, on the one hand, you're saying the issue here is that the purchase agreement was fraudulently induced and it's void, and that's how you get around the forum selection clause.
Correct.
Now, on the other hand, I think you're arguing this case has nothing to do with the purchase agreement, and you're really arguing about an independent oral contract, but that's going to be proved up and is intimately associated with the purchase agreement. So I'm having trouble reconciling those two positions.
I understand, Your Honor, and that is cause for confusion in this case. What I was trying to explain, and I hope I make the distinction clear, is the oral contract was the beginning of the contract itself, and it stated the basic terms, which were, we will exchange this airplane and the new airplane. I will pay you $100,000 for brokering the citation to me, and then he gave Mr. Mitchell the inside information about the most he was willing to pay. So the acquisition price was the result of the oral agreement, the performance of the oral contract. That acquisition price was then plugged into a written agreement without Mr. Karon's knowing that it contained $400,000 in fraudulently obtained markup. And so I guess what I'm trying to say is, did my client sign the written contract? Absolutely. But as Iowa, I think there's plenty of...
Whatever the theory is, wouldn't you agree that at some point this contract is going to have to be litigated, either to bar the claim, to advance the claim, to prove up damages? I mean, is there a theory in which you're going to litigate this case and the purchase agreement is just not relevant?
Absolutely. The purchase agreement is void from the beginning. And there's
Well, isn't
lots
that
of Iowa case law
litigating?
that's, pardon me?
Don't you have to litigate that issue that it's void from the beginning?
Yes, and we've been denied that whole opportunity, and that's the problem with the way the defendants approach this case. They say, don't look at the facts, don't look at the type of fraud that is alleged, because this contract stands no matter what, no matter how much fraud we may have committed, no matter what we did or where or who it affects, you have to enforce this clause. And I think it's black letter contract law that you have to have an integrated contract. That's what Judge Kepros found in Lynn County before the case was dismissed and then refiled. Kepros looked at it and said, this written contract doesn't say anything about the compensation to Elliott. It doesn't mention the brokerage issue. It doesn't mention any of these issues that have now come up. And so how can it be an integrated agreement which would make that clause, which Your Honor referred to, enforceable? This whole idea of severability came about out of a desire to preserve parts of a legitimate contract that should be enforced even when another part of the contract is found to be void or unenforceable, which is a laudable goal. But it was never intended to encourage fraud or to allow a party to fraudulently induce someone into a contract and then take advantage of those provisions to commit fraud and obtain and keep their ill-gotten gains. I understand they're related, but I think they're independent. I hope I answered your question as well. I did as well as I could, Your Honor. In any event, what we just talked about demonstrates clearly there was no meeting of the minds as to the correct price for the citation 10. It was represented to be 5.8 when it was $5.4 million. There was no integrated contract, as Judge Kepros found, and I understand it's not raised judicata, but it certainly is important to me that a judge who looked over an enormous amount of evidence in this case said, this is not an integrated contract. I'm not going to enforce the contract I'm not going to find that it was an integrated contract. And more importantly, or I think as important, the fraud that is at issue in this case goes to the very heart of the deal. I will pay you this in exchange for this. It's not peripheral. It's not, I'll help you get your medical license when you come to Iowa. It's a different issue.
Would all the arguments you've made apply equally if we were litigating an arbitration clause?
I want to make sure I understand the question, Judge. I think they're different. I think there's a fundamental difference between an arbitration clause and a forum selection clause. The arbitration clause, of course, is we're going to have alternative dispute resolution of anything that arises out of this case. And it presumes, well, I shouldn't say that. I think the arbitration clauses are favored, and in fact, there's the Federal Arbitration Act. I think forum selection clauses traditionally have been looked at much more closely, and choice of law clauses more closely, because they're not inherently part of contracts. I mean,
the restatement suggests otherwise. I mean, it says, and I quote, the parties' agreement as to the place of the action will be given effect unless it is unfair or unreasonable. And then it says, there's a comment that says, a court will entertain an action brought in violation of a choice of law forum provision if it finds that the provision was obtained by fraud, which is not what you're arguing here. Right?
That's correct.
So really, at least the general thrust of the law seems to be that you apply kind of a similar approach to forum selection clauses that you do to arbitration clauses. That you have to avoid it, you have to show fraud with respect to the clause, not the transaction or the overall agreement. And in a sense, isn't it fair to say that really arbitration takes away more rights from you than a forum selection clause? You still have a right to a jury trial in Kansas, right?
No.
Well, that's a separate issue. Right, because of the choice of law. That's a separate issue.
Yes. Your Honor, I see my time is almost complete. we urge you to reverse Judge May's decision and remand the case for trial.
I have a quick question for you. Sorry.
Judge.
It's along the lines of what you just talked about, statute of limitations. So Kansas has a 2-year statute of limitations. Is that correct?
On fraud.
Okay. And where was that oral contract entered into?
Iowa.
And when did your client realize the fraud?
I believe it was early in 2015, I believe. It's in the brief, but I believe it was it was February of 2015.
Thank you.
Thank you.
Mr. Crowley, thank you. Mr. Rooney.
Morning, Your Honors. May it please the Court, Counsel. My name is Patrick Rooney, and along with my co-counsel Wesley Graham, I represent the defendants and the appellees in this case. The venue provision in this case, as has been noted during opening arguments here, is a broadly worded, mandatory provision. It specifically states that it covers any dispute arising out of or relating in any way to the agreement, but also the legal relationship between the parties and, most importantly, the subject matter of the agreement.
Well, but if there was fraud in the inducement, the ordinary rule is that when there's fraud in the inducement, the entire contract is void. Isn't that right?
Well, I would say that that is not entirely correct, Your Honor. The decision that the trial court relied upon, the Dakaris case, I think that's how you pronounce it, Dakaris, dealt with that very issue in the context of an arbitration claim.
Arbitration, and it emphasized the Federal Arbitration Act. Federal Arbitration Act, according to the majority in Prima Paint, was a very powerful statute that was mandatory in nature and pushed the result in Prima Paint. Dakaris was an arbitration case. And if you look under Iowa law, we say repeatedly in recent years at least that arbitration is favored. Look under 679.8.1 and 2, that's our arbitration statute. Arbitration is favored, arbitration is favored. Choice of law provisions have not been favored in the law. This is a separate kind of issue. Why should we apply the Prima Paint rule, which emphasized arbitration, to a choice of law provision, which historically have been looked at skeptically?
Well, Your Honor, first of all, with due respect, I believe that venue clauses, forum selection clauses in the state of Iowa have not been looked at necessarily skeptically. The law says that forum selection clauses are considered prima facie valid and should be enforced unless there's some compelling reason not to do so. That principle is based upon the concept that parties, particularly sophisticated parties like these, should be allowed to contract on issues like this.
I agree with all that, but when you have fraud in the inducement, it strikes me that goes to the very heart of the contract. And there are a series of cases. There's an energy claims case out of Utah, briefly, that is a fraud in the inducement case. It deals with forum selection, and it pulls down the entire contract under kind of basic contract law, at least an approach to basic contract law. This may be a minority view, but Utah and Georgia and a couple other states at least have gone that route. Why not adopt a law that says, well, if you want the forum selection clause to stand alone, to be separable, why don't you have a separate agreement or a redeemer clause that says it?
Well, there was an iteration clause in the agreement itself. It's a 19-page negotiated agreement between sophisticated parties, both represented by counsel.
Normally, you don't sever out a provision. I mean, this is a little bit of a fiction. We're saying, I think you're saying, I mean, I invite you to correct me if I mischaracterize, but you're saying, well, we want to sever out the choice of law provision. And that's going to, you have to show fraud to that particular provision. We're going to separate it from the entire contract. The rest of the contract may be subject to fraud and inducement,
right. But
we're going to move the severability. That's unusual, is it not?
Well, arbitration clauses are actually, as we noted in the brief, and many courts have found, are actually a form of a forum selection clause. They deal with the same basic issue. Where is the dispute, if a dispute arises? Where is it going to be held, and under what conditions is it going to be held? So the fact that this court in Dakar has said we're going to apply the prima paint rule to arbitration clauses impliedly assumes that for that type of clause, a clause that deals not with the substance of the contract, but with the question of where the dispute is going to be heard and the procedural issues associated with how the dispute's going to be resolved, like choice of law, whether there's going to be a jury waiver, those issues are going to be considered separately.
We don't have a statute. I mean, the federal arbitration statute pounds arbitration, boom, 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 boom. We don't have a statute pounding choice of law provisions.
That's true. I agree with that. But here's the problem, Judge, and this comes down to a basic practical problem. The district court is being told that this contract was induced by fraud. There is a venue provision in that contract. The court has to decide, is this the proper place for this dispute to be heard? If the contract was induced by fraud, then perhaps the answer is no. But if it was not, then the answer would be we should follow the venue clause. So you're in a cart before the horse situation.
I mean, this isn't like an unusual rule. I mean, maybe there's been reference to a minority rule, but the United States Supreme Court in the Bremen case and the Shirk case, the restatement, my research indicates the vast majority of states that have ruled on the issue apply the rule that to invalidate a forum selection clause, you have to show inducement as to the clause.
Correct.
Just like arbitration, isn't that right?
There are dozens of cases. We cited 8 or 9 in our brief. The opposing counsel has cited the one case, the Hoffman case, which is interesting because that case has not been followed by any other court. And what's interesting is that the U.S. District Court for the Southern District of Iowa heavily criticized it, called it an actual mistake. And
what do you make of Iowa Code Provision 679A2C? That's the arbitration, validity of arbitration is the title. And subsection C says that the arbitration provision is not generally binding for tort or claims other than breach of contract unless in a separate writing executed by all parties. You need a separate writing executed by all parties to have a binding arbitration agreement? I mean, does that have any implication here, do you think?
I don't think so, Your Honor, because this A isn't an arbitration case, and B, we have a written agreement on the forum selection. That's very broad and very specific. And it covers, by the language of that provision itself, covers all the claims that are in this case, the fiduciary duty claim and the fraud claim.
The point is you could have contracted to deal with this issue separately. You could have had what I call a redeemer clause. You could have a provision that says, and this choice of law provision is going to apply regardless of claims of inducement of fraud and blah, 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 and all that. If you had put that in the agreement, well, then you'd knock it home, I think.
Well, I suppose. I don't think anyone was anticipating this claim because my client obviously didn't believe they were committing fraud. And we're in a position where you have to accept the plaintiff's facts because there was a motion to dismiss. But I can assure you there are plenty of facts on the other side. We just can't argue them now because they're in dispute. And so there would be no reason from our perspective to put that in here. But I do note that the language is very broad in the provision because it talks about the subject of this agreement. So the subject of the agreement is the purchase and sale of this aircraft. And clearly that is what the claims in this case are about.
I'm a little bit confused. Justice Apple just cited a statute that talks about the need for a separate writing in an arbitration agreement. You said, no, this isn't arbitration. But you're asking us to follow prima and doc res or dec res. So do you want us to treat it like an arbitration situation or not? It seems like you're picking a little bit of both.
Well, I think the principle that the court adopted in Decares as to how to deal with this type of situation, we're asking the court to adopt. That principle is how do you deal with this type of upfront procedural provision in a contract that the plaintiff says is fraudulently induced? Now, none of the cases that I saw regarding arbitration turned on whether there was a separate arbitration provision that was somehow separate from the agreement. The arbitration clauses...
And my hunch is that, wouldn't that statute probably be preempted by the FAA anyway?
Well, I would assume so, and because the cases that are cited in the brief deal with arbitration clauses in the contracts themselves, not separate agreements, and I'm not sure why that would make a difference on this issue, because fundamentally the issue is how do you deal with this question of where the case should be heard when you have this separate claim that the contract was induced by fraud.
Is this an area of the law that requires certainty? I mean, aren't we better off applying a majority rule so the parties negotiating these agreements know what the rules are going to be? If there's a fight over the airplane, they're going to go to Kansas unless they were able to negotiate Iowa or something different.
Correct. I think that is important. The parties need to know that this type of agreement... If we decide
it the other way, there's certainty, and that's the way it's going to be. I mean, whatever we decide, it's going to give some certainty.
Well, I don't think so, Your Honor, because what the plaintiff is proposing is that the court somehow look at the issue of the case and decide, before it decides whether it's the proper forum, that there's merit to the fraudulent inducement case.
Here's a bright line rule. The parties have to agree that the forum selection clause is severable. Put that in the contract. Bright line rule. If that's not there, it's not severable. Bright line.
Well, certainly there's other ways to do things. But none of the cases that I've seen require that. In fact, there's dozens, as I said, dozens of cases that say that the forum selection clause issue should be treated exactly like an arbitration clause or a choice of law provision, because they deal with how do you deal with the dispute, not the substantive issues. And I think it's important to note that in this situation, the plaintiff is not being deprived of any substantive right by having this case heard in Kansas. That was their agreement up front. We would have this case heard in Kansas. There's connections to Kansas with regard to this transaction. The contract was entered into in Kansas. And so there's nothing that is depriving the plaintiff of any particular right there.
Say the contract was entered into in Kansas. Can you clarify that?
The contract specifically says that the parties deem Kansas as the site at which the contract is entered into for purposes of the transaction, and they did.
Weren't they actually in Iowa when they signed it?
I don't know for sure, but that's what they said in the contract.
It was the plane located in Kansas.
The plane was in Kansas.
So the subject matter was
subject
in
matter,
Kansas.
yes. And the pre-closing inspection took place in Kansas, and there were tax reasons why the transaction would be closed in Kansas, which the benefits of which the plaintiff accepted. So there's nothing inherent about Kansas depriving the plaintiff of any rights. Kansas has a fully developed judiciary. The federal and the state allow them to have their case in court, and there's nothing particularly bad about that. The fact that the plaintiff brought this case, spent 18 months preparing for trial, only to dismiss it 11 days before trial, was their choice. They did that. We didn't do that to them. If they have lost out on rights because of that, that was their choice. I'll also say a slightly different issue, but counsel has cited Judge Kepros's rulings from that case, and I think it's important to note that that case was voluntarily non-suited by the plaintiff under Rule 1.943. The non-suiting of a case renders whatever happened in that case a nullity. The plaintiff can't rely on positions taken by the defendant in that case or rulings in that case. It's as if it didn't happen. And it is fundamentally unfair for the plaintiff to try to cite to that case having non-suited it. We're dealing with this case here now. This case is the one that's before the court. This case was filed, for whatever reason, 13 months after the first case was non-suited. Plaintiff chose to do it that way. We don't know why. And if they lost rights by waiting those 13 months, that is because of their decision, not anything the defendant did. All we're asking is that the provision that addresses where this case should be heard be enforced, because that is the only rational, reasonable way to deal with this kind of situation. Otherwise, you end up with the question of whether there's merit to the case being heard before the decision is made as to what is the proper forum. And the net result of that, as we point out in the brief, can be a situation where you go through an entire trial only to find out you were in the wrong forum to begin with, and the case has to go somewhere else to be tried.
Mr. Rooney, do you agree that the choice of law provision would be out if it was induced by fraud?
I think that the case law is clear that the choice of law provision, like a venue provision, like an arbitration provision, is treated in the same way. It's considered separate from the substance of the contract, and if there's allegations with regard to the choice of law provision being induced by fraud, then it can be addressed in that regard. But if there are no allegations regarding the choice of law, it's simply just like an arbitration provision, and it would be up to, ultimately in this case, up to the Kansas court to decide what law should apply. But it would be in Kansas, and the Kansas court would make that determination, separate from a conflicts of law analysis.
Thank you, Mr. Rooney.
Your Honors.
Mr. Crowley may present your rebuttal.
Thank you, Your Honors. While I do not claim to be a contract scholar by any stretch of the imagination, I always loved my contract professor's comment the first day he came in. He was the dean of the law school at Creighton, and he said, "You're going to be a lawyer out there writing contracts, and every one of your clients is going to want you to write the clause that says, 'I win no matter what.'" He said, "Be very careful with those clauses because courts don't like them." I think the fundamental issue that we're all grappling with here is that the contract restatement, which the court noted, implies or at least assumes that when people contract, particularly with powerful clauses like these, and my client was a sophisticated businessman, as was Elliott Aviation, when Exhibit AA was signed. The presumption, though, in enforcing those provisions is the equal bargaining power and knowledge. The whole idea behind Iowa's long string of cases that say that fraudulent inducement means that the contract is void ab initio is based on the understanding that if one party doesn't know they're being defrauded, they sign the agreement, an agreement they should have avoided to begin with. I think it's reasonable to assume that if Mr. Karon had been told before he signed this contract that, oh, by the way, we didn't pay $5.8 million for this plane, we paid $5.4 million, and we're marking it up, not the $100,000 you agreed to pay, but $500,000.
But wouldn't you have to get through all the merits under your approach? Don't you have to litigate all the merits of the case in order to decide whether the forum selection clause is enforceable or not? Isn't that what you're saying?
I don't know if that's true, Your Honor. I think you could do it in stages. I think you could probably have a hearing to determine whether or not that was a jury question. And I understand that today's arbitration clauses are designed to speed up.
I mean, you'd have to show, under your approach, you'd have to show the whole contract was induced by fraud and is void ab initio, which would then require you to prove up your entire case. And then only then would we know whether the forum selection clause is enforceable, right?
That's correct, Your Honor. I guess in a strict sense that is correct, but tort law governs this case. That's why we started out. Mr. Karon didn't enter into this deal expecting to be defrauded or to have his agent, for purposes of purchase, breach his fiduciary duty. And I think that's something that's just simply unavoidable in the interplay between human beings. When one cheats another and convinces them to sign an agreement, I don't think you can look to the agreement and say, well, you were a fool, you trusted him. Maybe you didn't know what he knew or they knew or she knew, but you signed it, and so now, you're just out of luck. And that's why, as Justice Apple pointed out, Iowa statute says when it comes to tort issues, arbitration clauses are not necessarily enforceable.
Is this really a fraud in the inducement claim? I mean, aren't you really arguing fraud in the performance?
Yes.
I mean,
But I think
right.
that-
I mean, your client wants the plane. The issue here is the representation regarding the price.
I think
Right.
it's not just semantics, Your Honor. I think you hit the nail on the head, though, because I think the fraud was committed in the performance of the oral agreement, and then the acquisition price was inserted into the written contract following the original fraud, which then continued. That's the way I prefer to look at it, because if they hadn't committed the original fraud in the oral agreement, it would never have appeared in the written contract. And so what's clear here is we want to enforce the integrity of contracts. We want to uphold the honesty in dealings between commercial interests and individuals. But we also want to uphold the legitimate interests of the state of Iowa. And one of the issues that I heard that I want to touch on before I run out of my 40 seconds is this. I think, indeed, forum selection clauses are much different than arbitration clauses because they do threaten to take away the power of the state of Iowa to right or wrong. Forum selection clauses take the ability of the state of Iowa to apply its norms, its societal rules to protect its citizens, and that is why they are so different and why they should be carefully and significantly limited, particularly in these situations where we do have a contract that was void at the outset. Thank you.
Mr. Crowley, thank you as well. Mr. Rooney, thank you again. The case of Karon versus Elliott Aviation is now then submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.